Your Worship, we are ready to start at last. At last, Worship. Thank you, Worship. Okay, let me first put the matter on the roll. Oh, yes. Your Worship, this is case number A604 of 2026, State versus Corpus Janssen van Rensburg. Can you bring all the accused up? Worship, as they are coming up, how do you prefer to stand? That one, this side, or okay? Thank you, Worship. Thank you, Worship. Okay. Gentlemen, I'm going to ask you to stand in this order. Now, Corpus, this side. Thank you, sir. Mr. Sibande, number 2. Mr. Mackenzie, number 3. Ms. Stolz, number 4. And then number 5 is Julius Mkhwanazi. Your Worship, they are in that order. Your Worship, this is the first appearance, and the date today, Your Worship, is the 6th of August in 2026. And the appearances are as follows. The personal officer is Mr. Mashiko. The state is represented by Advocate Ndelwa and Advocate Makasana. For the defense, they are as follows, Your Worship. They will correct me, Your Worship, if I didn't get them right. For accused number 1 is Mr. Nel. For accused number 2 is Mr. Van Heerden. For accused 3 and 4 is Ms. Kiwi. And for accused number 5 is Advocate Wilkins. And the matter, Worship, this is the first appearance today.
May I just give the question before?
Thank you, Worship. Can you pass this?
Yes, Council, before we proceed, I just want to place something on record.
Yes, Worship.
I've been approached in chambers by the legal representatives of the accused, Mr. Nel, Mr. Van Ms. Katie, Advocate Wilkins, instructed by Mr. Sali,
Yes, the state.
Mr. Deba and Mr. Makasana, representing the state, and then Mem Mahajana, spokesperson of the NPA, Ms. Priscilla Lewis, representing the media houses. So the purpose of them approaching me in chambers was to bring an application or several applications, and then the following conclusion was reached. Or before that, let me just place on record the media houses without mentioning the names of those people. Kasi FM 97.1, and then the Star, MBN TV, Media 2024, Netwerk 24, UFM, Kaya FM, Power FM /Dilisan, News 24, Newsroom Africa, ENCA, Kirsten Local Media, and SABC TV, and then the last one, Kai Media Eyewitness News. Having perused all the applications and having given the representatives chance to address me in chambers, the following order has been made. The court permits the following. One, that the proceedings be televised. Two, proceedings be broadcasted. Three, that there may be tape, photographs be taken, and then, however, pertaining to the photographs, there are some limitations or conditions. The conditions are as follows. The faces of the prosecuting team should not be shown. The face of the presiding officer should not be shown, as well as the faces of the investigating team in this matter. And then lastly, no communication should be recorded between an attorney and his respective client. And then that is what I agreed with the representatives in chambers. I'll start with the prosecuting team. Do you confirm about the above?
I do, Your Worship. That is correct, Your Worship.
Mr. Mayor?
I confirm, Your Worship.
Mr. Van Heerden?
I confirm that it's in agreement with the agreement that was reached.
I
do confirm, sir, Your Worship.
Advocate Wilkins?
Your Worship, I confirm subject to one clarification, that is that the request was also that the media houses not record any communication between the attorneys amongst themselves.
Yes. No communication between the attorneys should be recorded.
As it is the court.
Thank you. Counsel for the state.
Thank you, Your Worship. Worship, may I first find out if the lady next to actually number 5, if she is there for what purpose, maybe? Oh, media. Oh, sorry, Worship. Sorry, Worship. I was thinking maybe.
You were thinking of accused number 6?
Yes, Worship. Now I was not thinking because I have all 5, Worship. Thank you, Worship. Worship, this matter is on the road for the first time today, and Worship, the schedule involved is Schedule 6, because Worship, that there is a murder that happened in the course of robbery and by a group of people. That makes it, Worship, now in the premise of Schedule 6. Worship, the state oppose the bail release on all the applicants if they apply for bail. So, Worship, let me stop there. Thank you, Worship.
Before I engage in legal representatives, I wasn't told about language spoken.
Okay,
by the
sorry, Worship.
citizens. In which language does each prefer to proceed?
Worship, if Mayor agrees with court of law for accused number 1, Worship. Accused number 1's mother tongue is Afrikaans, but he's fluent in English and he will be able to follow the bail proceedings in English, and they have instructed me that I can place on record, Worship, that we can proceed in English with regards to accused number 1.
Mr. Van Heerden?
Thank you, Worship. Accused number 2 will need his services for isiZulu interpreter.
I noticed that Mr. Mpofu is here.
Understood.
Ms. Kevin?
As it is the court, Your Worship. Your Worship, I do confirm my appearance in respect of accused number 3 and 4. I further confirm that the proceedings may be conducted in English, Your Worship.
Thank you. Counsel?
Your Worship, as it is the court, accused number 5 is proficient in English. He is happy to proceed in English. He does not need to.
I thank you. Mr. Nell, are you in a them with the state that it's a Schedule 6 bail application?
Worship, with regards to the charge sheet, what was handed to me this morning, Worship, and the charge of profit by the state, Worship, it's indeed my submission on that grounds. Subject to the court maybe make a different finding, that we agree that this is a Schedule 6, Worship.
Mr. Van Heerden?
Thank you, Worship. I'm in agreement with Mr. Nell, and I also confirm that accused number 2 only received the charge sheet this morning.
Ms. Casey?
As it is the court, Your Worship, I do confirm, Your Worship, that I concur with both of my learned colleagues in respect of the schedule being number 6.
Council?
Worship, we do not intend to be difficult, but we do not agree that it is Schedule 6. We've been provided with a preliminary charge sheet, and I submit that from a reading of the charge sheet, it is quite clear that the charges against accused number 5 can never constitute a Schedule 6 offence. Worship. In this regard, also furthermore, in effort to clarify this, we send further particulars and request the state to provide us with further particulars. My learned colleague confirmed that he received it, even though it was sent to him yesterday, he indicated he only received it this morning. We have not been provided with those further particulars, Your Worship, and until we have been provided with those, and I will address Your Worship on this issue because I think Mr. Nell is going to take, will address Your Worship on the preliminary issue. But until we have been provided with that, on the charge sheet as it stands, we cannot agree to the fact that it is Schedule 6. We will address Your Worship with regards to further particulars, why we seek it, why we're entitled to that, and request Your Worship, after my learned colleague on behalf of accused number 1 address Your Worship, as to that Your Worship should make an order compelling the state to provide us with these particulars.
So as I understand, you are not ready to proceed.
Your Worship, we are ready to proceed, but we are not ready to consider this Schedule 6 offence. What we, in addition, inform Your Worship is that if we proceed as it is at this stage, Your Worship, we will follow the so-called scattergun approach. We will not be able to focus on what might be in dispute because the state has not indicated, other than the fact they claim it's in Schedule 6, why they would oppose that in this regard. So until we have that information, Your Worship, we have to address all the relevant issues, which in itself will prolong unnecessary proceedings. But we are ready to proceed, we are ready to continue. But without our further particulars, the right to bail, as was said in Mark's case, Your Worship, and confirmed in Green's case, will become illusionary. So we're ready to proceed, but without the further particulars, we will be severely hampered in the presentation of our case.
Counsel for the state?
I think, Your Worship. Your Worship, I don't understand the assumption of my learned friend that they have asked for further appraisals for the purposes of bail. Your Worship, I told him that we only received his correspondence this morning. That's the first time I saw that. And it was now the time for the court. Unless he's not ready, then we go back and I read and then reply, on those. I didn't get the chance to read and apply my mind to them. I just saw that there is an email from him about the proceedings. And Your Worship, I think the issue was now whether are we all added that this falls under Schedule 6. And Your Worship, the charge sheet is clear that there is a deceased person. It's a murder count. There's a robbery as a second count of the same person. CPA, Your Worship, is clear that in those circumstances that falls under Schedule 6. I think, Your Worship.
Would you like to reply?
Yes, Your Worship. If I may, Your Worship, what we asked my learned colleague, even this morning, was to provide us with an indication of why bail is being imposed. That has not been done, and the answer was simply that the state intends to wait until we have presented our case, and then they will decide on what basis they want to propose. Your Worship, I respectfully submit that is an improper way to conduct this, but be that as may, my learned colleague can deal with his case as he. If I may then refer Your Worship to the charge sheet, Your Worship. Before it is claimed that all the charges against the accused is set out.
Before you proceed, the applicant's name is
Your Worship, before the charges against the accused are set out, there is a preamble to the charge sheet. I do not know whether Your Worship has been provided with the copy there. Your Worship will see that the preamble sets out the facts on which the state will ought to rely. Your Worship will see that if we turn around to page 2,
That unmarked page 2.
unmarked page 2,
Yes.
it's the reverse side up in front. That's the one, the copy we've been provided with. You will see that at paragraph 1 on the first page, it sets out that, or it states that there's been a robbery in which the deceased had ostensibly been involved, some may with the other, that this information was conveyed on the 14th of April to some of the accused. Paragraph 3, that 13 members from the SABC, EMPD and private security companies can ransack the premises where the deceased was found. And at paragraph 4, Your Worship, when he could not move anymore as they assaulted him, they thought he was dead and decided to involve 5, accused 5. When he later arrived at the scene, I say it says the later, I suppose it must be he later arrived at the scene. He came with a plan to dispose the body into the nearest dam, which is approximately 23 kilometers away. Your Worship, so it is quite clear on the version of the state that accused number 5, on their version, on the charge sheet, can at best be an accessory after the fact, after the murder. That is not a Schedule 6 offence. Your Worship, the following paragraph also says that, and it deals with the robbery. During assault on the deceased, others took for themselves items from the deceased premises. Your Worship, now, this is clear. Also, before accused number 5 would have been said to have arrived at the scene. Your Worship, there is no mention made in here of common purpose with accused number 5 of the others, when such common purpose was formed, because according to the state, he was only, they decided on his involvement only after the deceased had died. So, Your Worship, on these facts, there is no evidence of a Schedule 6 offence that accused number 5 could be involved. So, it is against this background that we require clarification, and we drafted the request for further particulars, which has not been provided. We suppose, and if we come to that stage, Your Worship, we will request Your Worship to order the state to provide us with the details that we've requested, unless the state now intimates that they will provide it to us, and then we will reconsider our position. But at this stage, Your Worship, we cannot agree that it's a Schedule 6 offence.
Yeah, by the submission by the council is that he did not receive that request in time. Unless
Yes.
you request a postponement so that you can answer,
Your
you can
Worship,
reply.
yes, with all due respect to my colleague, that information can be provided us orally as well, verbally. You do not need to have a postponement for. Your Worship, especially the grounds of opposition. Tell us why you're opposing it.
But you say you are ready to proceed
We are ready to proceed, Your Worship.
without further particulars.
Your Worship,
With or without particulars.
yeah, obviously that will have an impact on the fairness of the bail proceedings and whether you have a fair hearing, but that is like an issue to be solved at a later stage.
I have taken note of that. Right, Mr. Nel, Bailey's opposed.
Yes, Your Worship. Before we commence with the bail application, Your Worship, accused number 1, which will become applicant number 1, Your Worship, is eager to proceed, Your Worship, and we have drafted an affidavit. However, Your Worship, before we commence, Your Worship, and the court know bail application is a unique procedure, sui generis on its own, Your Worship. And it will be my respectful submission, Your Worship, that the state, taking consideration the date of April 2022, 14 April 2022, on the charge sheet, that we, before we even commence that, they may be placed on record, Your Worship, if the investigation in this matter is completed, Your Worship. I would just at least want to hear from them and then address the court further. If the investigation in this matter is completed at this stage, Your Worship, because this is imperative also for how we address the bail application, Your Worship. And I don't think this is an unfair question for the state to merely advise us, are they still requiring further investigation, or is the investigation at this stage complete? And then I will address the court further if the court allows me, Your Worship. As the court pleases.
Councillor, for the state.
Thank you, Worship. Your Worship, to answer directly in this one, Worship will be given as a state our time to present our case. Can I reveal everything at that time when we are presenting our case? Because the investigation officer will be able to give all those details. Thank you, Worship.
Just answer, Mr.
Your Worship, with the greatest respect, and I will have to request the court to order them to provide us with answers. We have the evidentiary burden on us to pass the muster, to show this court on a balance of probabilities that exceptional circumstances exist for us to be released on the bail. My learned colleague referred to court to State versus Green. Now the state is telling us we're not even prepared at this stage before the bail proceedings start to tell you if the investigation is completed, Your Worship. They fail to advise us on what grounds a bail is opposed, Your Worship. Your Worship, the state is silent, as my learned colleague placed on record, Your Worship, and it was not disputed by the state, Your Worship. So this is facts. The indication to us was, we are not telling you while we're opposing bail, we're keeping quiet, first present your case and then we will tell you. The question must be asked, Your Worship, before we proceed with this bail application, is that fair and just? Was that the legislature's preview to say, you are blind, we're not giving you that? We know this case law in constitutional court cases with regards to bail comes from 4 years of State versus Mohawk, Dlamini. Your Worship, the state cannot just barely tell us in the dark that we have to shoot in the dark and fend for ourselves. If this was a trial, we would have said to the court, this is an ambush by trial. But this is an ambush by, the bail application is an ambush, Your Worship. They refuse to tell us on what grounds they pose. They refuse to tell us that if the investigation is complete. A simple fact like that, Your Worship. Surely we're entitled to at least have that, Your Worship. That brings me further to another application, Your Worship. The accused was arrested on a J50 warrant of arrest, Your Worship. There should be common cause between the defence and the state, Your Worship. They were invited to come and attend court, and a J50 was issued. On the time when we received the J50 warrant of arrest, we requested, myself and the attorney for accused number 5, requested the state to consider to provide us with a copy of the affidavit that was utilised to obtain the warrant. Your Worship, and Your Worship, for lack of now quickly remembering Safety versus Security 2016, Your Worship, if I might just address, Your Worship, get a citation to the court, Your Worship, Gongwana, Your Worship, Golf, Oscar, Kilo, Whiskey, Alpha, November, Alpha, Gongwana versus Minister of Safety, NO, and others, in brackets 2-668/2014, close brackets, Your Worship, 2015, ZASCA, page 186, is authority, Your Worship, in support of this, where although this application for or court case dealt with a search warrant, Your Worship, the Supreme Court of Appeal found that when you present a warrant, that was for the search warrant, and I submit that this is also applicable to a J50, a warrant of arrest. When you submit a warrant, the recipient is entitled to a copy of the affidavit, which is the document, the source document for which this was authorized. They blatantly refused that, Your Worship. We tried to have discussions, and I'm saying with the greatest respect, to discuss this, and the viewpoint I got, and if I misunderstood my learned colleagues, Your Worship, I do apologize for that in advance. But when we discuss, the sentiment was, do not discuss this in the hall, address the court. This is my first opportunity now to address the court. That is what they decided. They don't want to talk to us outside. Let's address this in court, and that's why I'm only bringing this point up at this stage, Your Worship. Surely, and that will be my second request to the court, to order them to provide us with the affidavit
that was utilised in support of the J50 warrant. Bishop, if we look now Section 43 of the Criminal Procedure Act, and with the greatest respect, I'm not here to educate this court. I know this court knows that section by heart. I mean, I believe the court have signed numerous J50 warrants or similar warrants in Yeshup's career. But the section says you can apply for a J50 warrant on evidence under oath. Without that evidence under oath, the J50 cannot be authorized. Yeshub. The mere question or request on behalf of applicant number 1 is to request this Honourable Court to order them to provide us with that affidavit under oath.
So, in other words, if that JPT is provided to you, Mr. Mayor, you won't be ready to proceed.
I have the J50, Your Worship. I just need the affidavit. Yeah, Your Worship, then we're ready to proceed, Your Worship. At the worst scenario, there will be 1 or 2 tweaks that we have to do to address certain issues. But at this stage, Your Worship, and that's the position, and I'm saying to the greatest respect to my learned colleagues, Your Worship, that's the position which that places us in, with blatantly refusing to provide you with any information. They tell you, guess what we have. And this is not a guessing game, Your Worship. If I did that to this court, the court would have said to me, Mr. Now, the court is not here to play games. But now the shoe's on the other foot. The state, with the greatest respect, are playing games. They're not open and giving you a proper charge sheet. Your Worship, I don't want to go even through the charge sheet. It's vague and it's embarrassing. But that's their charge sheet. That's the charges or the basis and the summary the state based their case on which they opposed this bail application. Your Worship, with the greatest respect, Your Worship, the fact that it's a Schedule 6, there's sufficient case law, doesn't mean the state has to oppose. They have to at least tell the court, tell us why they're opposing bail, seriousness of defence, flight risk, and so forth. And every accused will then be able to at least understand what burden he has to pass, Your Worship, for the court to consider bail. However, Your Worship, and I'm saying we've drafted, I will proceed on an affidavit. I'm just requesting the court, A, tell us if your investigation is completed after 4 years. Surely, if they decided after 4 years to issue a J50 warrant, the common cause and out of practical experience, Your Worship, we all know the investigation ought to be finished. Otherwise, why waited 4 years? Secondly, provide us with the affidavit, the evidence under oath for the J50 warrant. That was a copy provided to us. So it's not something that we don't know. They gave us that, Your Worship. And that is what I require this court to provide, to order them to provide us with that, Your Worship. This is something that can be, a copy can be made, provided to us. We can be provided 15 minutes. And we can be ready to proceed in all likelihood, Your Worship. Your Worship, the court have indicated in chambers that the court is not having any other matters at this stage and can attend to the bail application without prescription to this court. And I'm saying that with the greatest respect to this honourable court, Your Worship. We can always commence at 1:45 or 2, and we have time to complete this and finalise it and proceed with the bail application from 2 o'clock, Your Worship, for the state to provide, with regards to applicant number 1, at least that information, Your Worship.
Don't you think that, suppose at the conclusion of the applicant's case,
Yes.
the state presents evidence, are you not going to be given a chance to cross-examine the witness and find out that the investigation is finalized?
Your Worship, if the court sees it like that, I just want, the court must remember, I understand the Act, and that is how it will be argued. First of all, I have to start with my application, and I have to discharge the burden that's rests on the applicant number 1. If the court says to me, without what we're saying in the affidavit, the state will still have to present their case, it's a different story. But that is how the court sees it, and how the defence, the state are seeing it, Your Worship. I will have a different viewpoint. But as I understand, and I may be incorrect, I have the burden to prove, or the applicant number 1 has the burden to prove and discharge. And pass the muster, Your Worship, where he says on a balance of probabilities, there's exceptional circumstances. Now, how do we do that if the state doesn't present a case before this court, or tell us we haven't met that threshold for them to present any evidence? Will that be a fair and just bail application? Will that be, in terms of the Constitution, everyone has a right to have freedom to be released on bail if it's on reasonable grounds and it's in the interest of justice? That's my fear. If they say to the court, doesn't matter what they present, we will present further our evidence, then it's a different story, Your Worship. Thank you, Your Worship.
Any further applications, Mr.
Your Worship, just to add on, as far as Mr. Nell's concern is concerned, and the court's response that the defence will be entitled to supplement the applications after the state has adduced their evidence. And quite correctly, Mr. Nell in the first place said there's no guarantee that the state will have to file any or lead any evidence in opposition of the bail application. So that is not a guarantee. So the problem is that with the facts that we have at the moment available to us, we could deal with that to the best of our abilities. But the state may come and argue that that is not sufficient to be released on bail in respect of the Schedule 6 offence, and that the accused has not, or the applicants has not mustered the burden that and the onus that rests on their shoulders. The second point that the court also mentioned is that it may be clarified by cross-examination of the witnesses that the state may call. There's no indication that the state intends to call viva voce witnesses. We cannot cross-examine an affidavit. So, and obviously the state has also got the right to file an affidavit in objection to the bail application, and then the accused is still sitting with the problem that they're not in a position to cross-examine or to question the evidence that has been adduced by the state. And that is the problem.
But Mr. Van Leeuwen, if there's no sufficient evidence before the court may exercise its judicial discretion to call a witness who will be subjected to cross-examination either by the state.
Your Worship, the key word in the remark of the court lies in the court may. It's not that it will happen. It may happen that the court may elect that the witness be called. The court may also decide that it is not necessary to call a witness, and then the applicants are in the same position that they've been conducted to, and my learned colleague Mr. Nell correctly referred to it as an application by ambush, because we don't know what we need to meet. The state says, show us your cards, we will decide upon that whether and how and on what basis we're going to oppose the application. We don't know, and it's my respectful submission, by following that approach, it's just delaying the matter, because what is going to happen if the state at some stage disclose their opposition, the applicants will have to reopen their cases and lead further evidence, and that is just going to be an extension and a delay in bringing the matter to finality. It's my respectful submission that the prudent way will be for the state to supply the information that was referred to by my colleague Mr. Nell as well as Advocate Wilkins, and that we can proceed once we've got that.
ukuthi-ke lona mniningwane yonke iyayidinga phambi kokubuso kwenkantolo ngezathu sokuthi ukuma-ke mina ngizofaka-ke sami isicelo ngikhiphe-ke okwami kokufakazi ukubonisa ukuthi cha mina ibheli-ke lena-ke iyangifanekela, kepha-ke ukuma-ke mina ngiyakhipha lobo bufakazi lobo. Nina-ke mase kumele ukuthi ngiyibuze imibuzo kanjani, ngoba kwamele ukuthi nami-ke ngizilungisele ngibone ukuthi obuphi ubufakazi nina obunabo obukhombisayo ukuthi-ke mina ngiyanqabela-ke ngebheli noma-ke nginqabe ngebheli. Kepha-ke kwamanje njengoba inkosi yenkantolo iyasho ukuthi cha mina ngane ngahamba kulesicelo lesakho sebheli, ngisho-ke nakumbuso ukuthi cha mina khiphani kobufakazi noma-ke ngizobiza mina-ke owami-ke umuntu uzomele ukuthi-ke akufakazele ukuthi yini isizathu ukuthi nqabe ngebheli. uthi kumele lokho cha lokho kuyafana nokuthi ngiyamnqabela ngebheli ngoba angeke size sikwazi thina ukuthi yini lena esombuza yona noma ke kumele simele amakalithi affidavit angikwazi mina ukubuza affidavit ke embuzo ngokusho kanjalo ngiyaxhasa ke lokhu kuyokushona ke umnumzane ke nalo ukuthi khiphani ngeke obeni kuyofakaza obukhombayo ukuthi yini izathu nginqabela ngebheli.
Thank you, Your Worship. Your Worship, safe to state that or rather it is common cause that the state is opposing bail. I do concur that as we stand here right now, no reasons have been furnished as to the grounds for the opposition insofar as the state's position is concerned. However, Your Worship, in saying that, I do confirm that I am not ready to proceed with the bail application today in respect of accused number 3 and 4, Your Worship, as per the report.
Yes, Your Worship. I indicate to you, I expressly want to reserve the right, if Your Worship is so inclined to indicate why I submit we are entitled to further particulars. But Your Worship, just in respect of the issue of the bail and why it's being opposed, if I may just provide Your Worship with some background to enable Your Worship to understand why it is of the utmost importance for us to understand why bail in respect of accused number 5 is being objected to and opposed. Your Worship, accused number 1 was arrested initially in Boksburg, before Boksburg Boksburg Court, and bail in that application, Schedule 5, was opposed. After the opposed hearing, he was granted bail. Thereafter, the accused number 5 was again arrested and brought before court in Germiston on a Schedule 5 offence. There was no objection to him being granted bail. My learned colleague on behalf of the state was part of the prosecutorial team that took the decision not to oppose bail in that application. Your Worship, accused number 5 was then again arrested and brought before the Joburg Magistrate Court, where he appeared on a Schedule 6 offence. There, the team leading the prosecution, including my learned colleagues, chose, despite the fact that it was a Schedule 6 offence, not to oppose bail. Bishop, now we are charged again, we are arrested again. We brought before court, and after this concessions by the state in these two previous occasions, Schedule 5 and Schedule 6 offence, that we do not oppose bail. Now we are told that the bail is being opposed. So Your Worship can, with respect, understand how we are perplexed at this stage by the state who had previously adopted an attitude by we not opposing bail, even on a Schedule 6 offence, when we told we are now opposing bail. And we're not told why. Your Worship, so with a greater respect, at the very least, we submit we're entitled to be informed why bail is being imposed at this stage, so that we can address this issue now. Bail application issue.
You imply that the state should provide us with a certificate from the Bishop Director of Public Prosecution that Section 6 bail application.
Your Worship, if that is the way the state wants to do it, that is one way of doing it. But yeah, Your Worship is just merely providing us with information so we can decide for ourselves whether it is a Schedule 6 or not. Then you don't have to wait and have to apply for the certificate. But Your Worship, we cannot at this stage make any decisions if we're not provided with that. And if Your Worship is inclined to hear me now, and I can address Your Worship now on why I say we're entitled to the information we sought in the request for further particulars, I will address Your Worship, so with specific reference to the case law that says that we're entitled to that at this stage. Should I proceed to Your Worship, justify that application? Your Worship, as I indicated, Your Worship, we are instructing attorney that directed correspondence to the prosecutor, and it was emailed through to the prosecutor yesterday afternoon, Your Worship. The transmission notice is attached to the correspondence, and it was done at 4:33 yesterday. My learned colleague considered he received it, but says he only received it this morning. Your Worship, in this we record, and I think Your Worship would allow me the opportunity to, that I should read in the contents of this letter. Your Worship, I'm not going to read into the record the heading, but I start with the content of the letter that is delivered and directed under the caution that it was extremely urgent. 1. We refer to the above matter and report that following arrangements with the lead investigator for IPEC, Mrs. Nomsa Masuku, our client handed himself over this afternoon at Benoni Police Station and was arrested. 2. We report that given the exigency of the matter and our client's instructions to launch a bail application as soon as is practical, Mrs. Masuku, initially giving the arrangements made for our client's handing over, indicated that the state may oppose our client's release on bail. However, at the handing over, Mrs. Masuku informed that whether the state would oppose bail, and if so, on what grounds, should be discussed with you as the prosecuting authority dealing with the matter. 3. Our efforts to reach you on your mobile since leaving Benoni Police Station have been unsuccessful. 4. Kindly advise, as a matter of urgency, given our client's appearance tomorrow in Brakpan Magistrate's Court, whether the state intends opposing our client's application, and if so, the reasons therefore. 5. Having been served upon our client's handing over with a warrant for our client's arrest, authorized on the 3rd of August 2026, the police have declined to provide a copy of the affidavit supporting the application in terms of Section 43 of the Criminal Code in support of the warrant. Your attention is drawn to the decision of Mkhwanazi, who is Minister of Safety and others. Your Worship, the reference was read into the record by my colleague, but for purposes of record, 2016 decision of one of the all South African law reports, page 629, the decision of the Supreme Court of Appeal, as authority in support of our client's right to a copy of such affidavit. 6. We also enclose our client's formal request for further particulars. 7. Please provide the state's response as a matter of urgency so that we may timeously, in anticipation of the appearance tomorrow, prepare our client's bail application. 8. Our client's rights remain strictly reserved. Kindly acknowledge receipt thereof. Bishop, I beg permission to hand up a copy of this letter together with the transmission record to your Worship. Your Worship, the request for further particulars was transmitted at the same time as can be seen from that letter to the state. And it commences as follows, Your Worship. In order to provide the applicant with a reasonable opportunity to prepare for his application for bail, and in the light of the decisions in S versus Mal, S versus Lamini, and S versus Kok, the following particulars are required by the applicant. Your Worship, I do not write the references in, it is part of the request. 1. A charge sheet, albeit provisional, setting out the allegations against the applicant with sufficient particularity as is required by Section 84 of the Criminal Procedure Act. The particulars here in short are requested to acknowledge that this charge sheet so provided is provisional only and that the state is not bound by it for purposes of a subsequent trial. But the operative words there, Your Worship, is that sufficient particularity. 2.1. A summary of the evidence on oath in the police docket is required. Alternatively, to subparagraph 2.1, the state is requested to furnish the following particulars. 2.2.1. What are the allegations against the applicant? In other words, the state is required to state fully and precisely how the applicant is linked to the commission of the offences being preferred against them. 2.2.2. Is it alleged that any of the co-accused and or the applicant were found in possession of any incriminating evidence linking him or her to the commission of the offences? If so, the state is required to furnish in respect of each of the co-accused and or the applicant the list of the items or objects found, when same were found and where same were found, and how such items are linked to the commission of the offences. 2.2.3. Does the state intend relying on any video and or audio recordings purportedly incriminating the applicant? If so, the state is required to furnish the applicant with a copy of such video and or audio recordings. Alternatively, a summary of the contents of such video and or audio recordings. 2.2.4. Does the state intend relying on any admissions and or confessions and or alleged pointing out made by the applicant? If so, the applicant, the state is required to state fully and precisely 1. Whether such admissions and or confession or pointing out was reduced to writing. If in writing, such application, the applicant requires copies of same. 3. If verbal state is required to state to whom such admissions and or confessions and or pointing out was made, when, including the precise time of same were made, where such allegations and or confessions and or pointing out was made. And 4. If it is alleged that the state will rely on any admission and or confession and or pointing out that was audio and or visual recorded, state is required to furnish the applicant with a copy of such audio and or visual recording. Then main 3 again, Your Worship. Will the state rely on written confirmation as referred to in section 60(11)(a) of the Act? If so, a copy of such written confirmation is requested. Your Worship has addressed that. 4. The state is requested to indicate the precise grounds on which the application for the applicant's bail on or release on bail is opposed. In this regard, the state is requested to give specific indications in relation to the likelihood that any of the following sections of the Act may be infringed should the accused be released on bail. Your Worship then goes on to refer to section 60, subsection 4, paragraph A, B, C, D, and E. 5. The state is requested to indicate the period in terms of section 69B of the Act. It is estimated the applicant may be incarcerated before finalization of the investigation and the trial respectively. Will the state 6 allege that no suitable bail conditions can be imposed in the granting of bail of the accused? If so, the state is requested to stipulate any bail conditions if this allegation is not enforceable against the applicant. And 2 reasons why the state may rely on this regard is also requested. 7. The state is requested to indicate the basis on which it may possibly allege that in the interest of justice do not permit the release of the applicant in a row. 8. The state is requested to indicate with sufficient particularity whether to rely on the common intent or purpose between the applicant and any of his co-accused and or other persons, and to state precisely what acts the applicant is alleged to have done in the furtherance of such common intent or purpose. And 9. The act is raised of the applicant with each of the co-accused in respect of each of the offences being preferred against the applicant and his co-accused. Now, Your Worship will note that this morning you've been provided with the charge that I've already referred to the Worship there, and I respectfully submit that the allegations therein contained is not of such nature that we are informed of the manner and the reasons why our client is being charged, and why it's alleged that it's a Schedule 6 offence, Your Worship. If I may then refer Your Worship to the case law, the case of Green, Your Worship. Your Worship will recall the facts of that matter. It's very might be acquainted with the case of Green. Your Worship, the reference there is 2006, volume 1 of the Criminal Law Reports, 603 SCA, paragraph 23. The SCA held as follows. It is clear from section 60, subsection 10, that the court's function in bail applications is intended to be more proactive than in normal criminal proceedings. As it was put in the Dlamini decision, at paragraph 11, a bail hearing is a unique judicial function, and the inquisitorial powers of the presiding officers are greater. On a proper consideration of the case on which the state relied, any reasonable court must have concluded that it lacked reliable and important information necessary to reach a decision, notwithstanding that such information was apparently readily available. In such circumstances, the court has no discretion but to invoke section 60, subsection 3. In my view, the magistrate should, instead of refusing bail without more, order the state to grant the defence access to the videotapes and any statement made by the police, the fingerprints expert, linking the fingerprints of either of the appellants of the crime with the decision on whether or not to grant bail to be made thereafter. Your Worship, there the court expressly said that we are entitled to some of the information and documentation that we seek in this matter. And in the Malk case, Your Worship, 1999, volume 2, South African Criminal Law Reports of the Transvaal Division decision 489 paragraphs C to D, the Honourable Justice Snyder's, Judge Snyder's, she then was, made it clear how the lack of discovery may hamper an accused person's right of the exercise to bail. And she stated as follows: the fact that an excessive onus had been placed on the applicant, it was held that he had not discharged the onus, despite the absence of countervailing evidence. And this I respectfully submit, Your Worship, despite the evidence of absence of countervailing evidence, deals with the issues raised by legal representatives of accused 1 and 2, where Your Worship addressed them the fact that this might be at a later stage provided. In that case, Your Worship, there was no countervailing evidence. There is no indication here that countervailing evidence may be presented. But I then, Your Worship, having interrupted myself, continued. Despite the absence of countervailing evidence and the fact that the applicant had not been given a reasonable opportunity to access the information in the docket, in this case had the practical effect that for the applicant, bail became illusionary. Your Worship, this judgment and the approach to be adopted was confirmed in the case of State v. Scott, 2003 decision, Your Worship, where the appellate division held as well that under these circumstances, further particulars should be provided. I was fortunate enough to have argued that matter, Your Worship. So I respectfully submit under these circumstances, Your Worship, that we are entitled to further particulars to enable us to decide what the grounds are on which bail is opposed, to enable us to deal specifically with those grounds, Your Worship. And that is very important, Your Worship. The state's resources is scarce. Your Worship's time is scarce. The time that we are wasting here is scarce. We do not want to become embroiled in a long, protracted, drawn-out application where we file an affidavit, we shoot in the dark, my learned colleague comes, he provides an answer, and we then have to address Your Worship again and ask for permission to supplement our affidavits. Your Worship, with the concomitant cost that comes into play for the accused, that prejudices them, the fact that that might inevitably lead to further postponements and additional and excessive waste of this court's time. So I respectfully submit, Your Worship, at this stage, the state should be ordered to furnish us with these details so that we can provide this honourable court with a comprehensive, detailed and focused affidavit that will enable this honourable court to reach a judged decision at the end of the day, and also enable us to use evidence that will enable us to dispose of this onerous onus that we are at this stage saddled with. Unless there's anything else, Your Worship, that is my...
So, in other words, you are not ready to proceed until you are provided with the information.
Your Worship, no, I reiterate, we are ready. If Your Worship says they are not suppliers to us, then we will proceed. We're ready to proceed. Your Worship, if they are ordered to provide this information, that might give rise to the postponement under those circumstances. But we are ready to proceed. Your Worship says no, then we are ready to proceed. I just take instructions from my... Worship, I might just place on record that we have prepared an affidavit. Affidavit is before court. We are ready to proceed, subject to the judgment of your, and ruling of Your Worship in this regard.
Right, there are other issues arose after the answer. And then after the state has replied, I'm going to give you an opportunity.
Quite busy, Your Worship. Your Worship, my learned friend, colleague wants to deal with this one, with this reply. Can I let him deal with it? Thank you, Worship.
Yes. The court, please, Your Worship. Your Worship, I'm a little bit confused as I'm standing up as to what is this, or as to what is it that the defense wants in the matter before court. Just to give a background, the matter, Your Worship, is the first appearance, as everybody knows, and we raised the issues with the defense prior to us beginning with the matter, when we said it would be better to deal with the remand and then deal with everything else on the next date. The defense was opposed to that. The reason why to have another date was the issue of enabling the defense to get whatever information they may be seeking between today and the next date. It is correct, we are dealing with a Schedule 6 offense, and I must spell it out for the record, Your Worship, as it is well known that the onus based on Section 6011, subsection A, lies with the defense to discharge two things. The first one being exceptional circumstances. Secondly, to show and demonstrate that it is in the interest of justice for the defense, or rather for the accused, to be released out on bail. So that is entirely on the shoulders of the defense when we come to Schedule 6 offences. But we were then advised that the defense is ready to start with the matter today. And then we said, okay, we'll accommodate you, we'll start with the matter and see how far do we go with the matter. None of these issues were raised outside the courtroom. Perhaps it is actually correct to place on record that everybody kept his card close to his chest. Now we are before court. We are told about the application. I'll start with the one of further particulars. It is correct that the federal request was made, as it is confirmed by my learned colleague. It was received this morning. On our way to court, one can even look at the content of what is required in that particular request. It's so much details. Nobody could even determine those details while driving to court. Any person that will have to respond to that will have to apply his mind and apply the law and come to a decision whether these are going to be furnished to the defense or not. It is not something that one can just stand up and say, I am replying to so much details that are placed before court. So, the reason why, Your Worship, I'm saying that I'm confused. Do the accused state before this court through their legal representative that they are ready to proceed? If that is the case, the legislation is clear that the onus is on them to place before court. And it is true that the state will have to respond. For that reason, the state does not even have to respond in the state grounds as to why they are opposed. But we are going to do that and place the reasons why before court why the state is opposed to bail. The onus is entirely on the shoulders of the defense. And we don't have a duty to even disprove what they allege and place before court. Now it appears as if the defense want us to create a ground upon which they will formulate the application in order to discharge the onus placed on their shoulders. And that is not correct, Your Worship. So I respectfully submit that if the defense want the matter to proceed, either they proceed by way of affidavit, as I think they are going to do today, or they call their clients to testify. The same way that they are entitled to choose, the state is also entitled to choose whether the state is going to use an affidavit or the state is going to call an investigating officer to come and testify before court. The state cannot be compelled. They cannot then premise their application to say that we don't know whether the state is going to call the investigating officer in order to clarify what we need to clarify. That is the discretion of the state, Your Worship. The state will decide at an appropriate time which method the state is going to use going forward. Now, I don't want the court to be so much burdened with so much argument. That is not necessary at this stage. I request, Your Worship, as I feel that the defense is not ready to proceed today, they want the state to provide information so that they can fill the gaps in their application in order to discharge the onus on their shoulders. So, we are ready to listen to their case today if they are so willing to proceed and then reply. It is correct, as my learned colleague here for the defense stated, that the bail application is sui generis in nature. The court can actually, if the court feels that there's information needed, the court can request that information to be placed before court. But to say at this stage, the state must divulge A, B, C, and D in order for the defense to build up their case in as far as discharging the onus is incorrect. The legislation is clear. If I may just put on record, just for the record, Your Worship. I understand that Section 6011A reads as follows: notwithstanding any provision of this Act, when accused is charged with an offence A referred to in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence with emphasis, Your Worship, adduces evidence which satisfies the court that the exceptional circumstances exist. That is what they are burdened with. Number two, which is in the interest of justice, to show that it is in the interest of justice to permit his or her release. Now, it is clear, Your Worship, that with the first one, it entirely depends on them. But with the second one, the state is where the state is more interested in this particular case. And the state is willing and ready to place that evidence before court. But the state cannot be forced by the defense to put the evidence before even they commence with what they are burdened with in terms of the law. We'll look into Section 60, all the likelihoods going down, to point out what is the state's view in as far as the likelihoods are concerned. So, Your Worship, I request with all humility that the defense at this stage, we have wasted a lot of time dealing with the issue that I think we should have tackled within a few minutes. The defense must indicate, are they willing to commence with the bail application as per the charges placed before court? Number two, if they are not, they still will require further information. Then are they willing that the matter be remanded so that the state can look into the matter and decide whether the state is giving this information? We are aware of the case law. It's just that we're not at that stage. I know the case of State versus Green. In fact, the defense should not demand information that will allow the defense to look over the shoulders of the state as the state is busy with this matter before the matter gets to trial. So I submit, my lord, that the defense must actually be very clear on this issue. Are they ready to proceed? If so, they must deal with the case as they said they were ready. If they still want information, as I said, it was a very short space of time that this detailed information was sent to the state by means of an email. Then the state should be allowed to give such answer to that particular application. Otherwise, we'll be going backwards and forwards around the same issue when the defense knows very well that they are not ready to proceed. That is the state submission, Your Worship.
Right, I noticed that it's 1:15, it's lunchtime. But before we adjourn for lunch, as advocate has submitted, the defense must indicate whether they are ready to proceed without that information which is required today, or if not, another date should be arranged for the application.
As it pleases you, if I may just address short, I'm going to keep it short. My learned colleague sidestepped. There was an application, and that's how I deemed it. And if I didn't make it clear, I do apologize. There was an application on behalf of applicant number one for two things. Before we commence with the bail application, is the investigation complete? Is the state, state prepared to provide us with an affidavit and support of the J50? The application before this court was for the court to order them, if they don't want to give it, or the court should dismiss my application, and then I'm ready to proceed with the bail application, Your Worship. But I cannot sidestep by quoting Section 6011A to the court in not responding at all to this court with regards to the application that's currently before the court, before the bail application can commence, Your Worship, as the court pleases.
But at this stage, we adjourn for lunch until 2 o'clock.
Yes, the court please, Your Worship.
But this is your background. That background is fine. Your background with you. Is it?
I believe this microphone can pick up the needle that falls at the back. No.
Giving them this further particulars. Because when I read Section 60, Subsection 14, indeed, it says the defense cannot get information from the state for bail purposes unless the prosecutor agrees. Therefore, Your Worship, that will give me time to reflect on their application and see which information I can give in to. Therefore, Your Worship, it is my submission that as an officer of this court, and for the court to reach the proper decision, I ask the court to allow them to get, to make that application, make it clear to me. Then I will look at that and supply the information that I can feel that they are entitled to. The court says it is my submission abound when it comes to that, because they read the whole application for the information for the record. So, Worship, it is my submission that may the court give us a postponement for us to supply the defense with this information where it is necessary as a court president.
Lokuthi-ke bahlanganise yonke-ke imininingwane-ke efakiwe kwesicelweni-ke sabomeli bonke lana phambi kokuthi bachubeke ngey'celo-ke lesi ezenu, ngoba ukuma-ke mangibheka mina noma-ke ngiphenya-ke lesicelo lesi basifakile, kwamele ukuthi-ke ngihlale phansi ngihlanganise nami-ke amathambo engqondo ukuthi-ke ngihlanganise-ke leyo mniningwane leyo. Njengoba kusho kanjalo-ke babusibani, ngizocela-ke nenkantolo lena inginikeze-ke ithuba lokuthi nami-ke ngilungisa-ke yamina.
Right. The only legal representative who is not ready to proceed with the application is Ms. Kevin before this court on behalf of accused number 3 and 4. And then other legal representatives indicated that they are ready to proceed with the application. However, having heard them, I'm quite convinced that they are not ready to proceed with the application. They would like to engage with the state pertaining to certain information. And then furthermore, I cannot at this stage order the state to provide the defense with required information. Hence, I'm ordering that this matter be prosecuted to a date to be arranged so that the defense and the state can engage pertaining to the matters at hand.
Usubala babusibani ukuthi-ke ummeli-ke lona umele umangela noma kumceli-ke phecelezi applicant wesithathu nalosuke wesine uye nje phela aveza ukuthi cha yena ngeke aze akwazi-ke ukuqhubeka ngale sicelo lesi-ke sebhenki. Kepha-ke ngokubona-ke kwami nawo wonke-ke ummeli wokuqala kubhekeke nommeli wokugcina kusobala ukuthi nabo nje abeka-ke banethuba lokuthi bahlanganise nawo amathambo-ke engqondo baqhubeke-ke ngale sicelo lesisenu-ke sebhenki. Ngizonikeza-ke umbuso ithuba lokuthi baqhubeke bona bayophinda-ke lokhu bafuna ukukuphenya ngalilanga leli-ke sokubuya nangaso khona ila-ke khona sokuqhubeka ngale sicelo lesisenu. Understood, Bishop?
Please, the court, Bishop.
Bishop, if I may just ask for clarity, and I'm trying to, if I overstep, the court can just, so I'm trying to, I just want to understand. It seemed that my learned colleague before the court gave the ruling was indicating that we should get time to provide this with the information. That's number one. And number two,
If I understand the court correctly, my apologies, Your Worship. My application, the court has indicated that at this stage the court cannot order the state for that. Therefore, my application in sense is dismissed. Thank you, Your Worship. I'm indebted. Thank you, Your Worship. And is that included with the state that tendered that they will provide it, or is that discretion remains with them, Your Worship? I'm indebted. Thank you, Your Worship. Thank you.
Your Worship, we did arrange, I don't know if that date still suits my learned friends, the 13th, next week on Thursday, 13th of...
Available on Tuesdays.
Oh, only on Tuesdays.
No, I would suggest that on Tuesdays.
Yes, we are not, I'm tied up on Tuesday.
On Tuesdays.
Yes, sir. Sorry about that.
No,
I'm available on Tuesday, Your Worship.
As a previous court, Your Worship, I confirm, Your Worship, that I am also available on the 13th. Your Worship, if I may just canvass one aspect. With reference to accused number 3 and 4, I obviously cannot speak on behalf of the other accused. I did liaise with my learned colleague for the state with reference to where they would be detained. It was my request and application, Your Worship, that they be detained at one of the SAPS departments themselves as opposed to correctional services. I'm not too sure what the position is, but it was a discussion that I'd had with my learned colleague for the state prior to us appearing in court, Your Worship. So if I may just obtain clarity on that aspect. Thank you, Your Worship.
Thank you, Worship. Indeed, we did canvass that point, Your Worship, indeed, and we waited to also liaise with the station commander. Worship, he has just supplied a very good answer that the station have enough facilities to accommodate them. So there's a green light. The station is the Brakpan, Your Worship. Sorry, Brakpan.
I'm engaged.
Thank you, Worship.
So, it should be attached on the charge sheet.
Okay, it's fine. Worship, may I also, in the process of handing it in, also hand in those warrants now. They've been executed for the court to cancel them. Thank you, Worship.
The court is in possession of the following warrants. First one is one of the previous Janse van Rensburg,
Yes.
50. And then the second one is one of the Ekurhuleni Wayans Brandi, 50. Third one is for Andrea Norman Mackenzie. Fourth, Leach Stores. And then this one for Mr. Mkhwanazi.
Court position.
All these J50 warrants are cancelled.
Court position.
As court decision.
Yes, I suggested a Tuesday, but the date is which will be your office.
The 13th, Worship, I think, is on Thursday, Worship. 1-3, yes, Thursday, Worship.
Is the 13th suitable, Advocate?
It is indeed suitable for me, Your Worship. That's the first date it's available.
Then,
I do confirm, Your Worship.
Mr. Van Heerden, you said you are available on a Tuesday.
I was available on the 11th, Your Worship, just to give preference to this matter, but due to the fact that the state is too busy for us, so I'm available on the 13th.
Thank you.
Mr. Nel?
I'm also available on the 13th, Your Worship.
Thank you. Mr. Van Rensburg, Janse van Rensburg, and others, please stand up. Matter is postponed to the 13th of August 2026 for further bail application. You will be in custody.
Ugcina-ke ngaphakathi esitokisini ke babusane ngethi bazoxoxa-ke ngomhla ka-13 evekilini elithwasayo besicelo sakho sephela.
Understood.
Thank you.
Court position. Worship, that's our role. Unfortunately, so. Let me just finish the worship. It's not here, worship. It's not here, worship. Thank you.